Hello, everyone. We are here with another legal reasoning session, which is on torts, and again, we are going to study torts today. So, thumbs up, दे दो मुझे फटाफट whether I'm audible and visible to you all. Okay, no worries. Let us go ahead with the first question. We'll see few of the principle and facts-based questions as well because yes, of course, we need certainly other exams as well, which we can go ahead and see. Plus, principle or facts वाले question में थोड़ा सा we learn a bit of the concepts as well. We'll go for the passages based questions also, but थोड़े से principal facts questions भी देख लेते हैं with respect to torts, right? So they are talking about private nuisance and public nuisance here. When you see the principle as such, right? So principle one states about the private nuisance, and principle two states about the public nuisance. So for the first instance, when you see the question, you can see both of the facts, right? Then we can see the facts, which is like there is a person who is constructing a new house way in the King's Way land. So basically, construction is going on. It's a nuisance that will be created. He directed an independent contractor, okay, to connect the sewer lines of his house to the main municipal sewer lines. On his directions, the contractor dug up an entire stretch of Kingsway land in order to carry out the instructions of A, right? As a result of excavation work, the main road leading to lane of which B's house was situated was blocked. Causing inconvenience to him and others, B brought a suit for causing nuisance against A. Decide. So while we see here the nuisance, okay. While we see here the nuisance part, we can see, okay, there was a construction work going on, and because of that, there was a contractor who dug up something, and then because of that, there were, the chaos created. And as a result of that, the main road which was leading towards the lane of which B's house got blocked. Now B brought have a suit. So what would be this? This would be a private nuisance or public nuisance? That is the first question of mine. Whether it would be something related to public as large. So when you see private nuisance का definition, आप देख सकते हो कि means an unlawful interference with person's right or enjoyment of land. Whereas public nuisances means unreasonable interference with rights common to public at large. So here are two concepts that we are learning कि पहले वाले में एक सिर्फ एक person के right को हम देखेंगे, public में हम common एक large public पे देखेंगे, right? So here according to that the answer should be A. The suit instituted by B will terminate in his favor as A's action amount to private nuisance, right? So something which is private in nature. Right. Moving on to the next question. When you see the next question, it is about again the private nuisance. We'll see the facts a bit that there were two neighbors. One was a famous musician. हम इस type के questions काफी solve कर चुके हैं already, and this is one of them, right? So V is a famous musician and has been running a music school from his residence from the last 21 years. There was no fixed timings of the students. Sometimes training of students went till late in the night. A was a senior citizen who took voluntary retirement from his job 2 years ago due to failing health. Soon after his retirement, he constantly asked B to regulate the visits of his students and fix the timing as a constant noise of music, especially during late hours of the evening, disturbs his sleep, thereby leading to further deterioration of his health. B paid no heed to the request of A. A decided to file a suit for the nuisance against the B. Okay, so whether this would be a nuisance or not, right? We should know it would be a private nuisance or a public nuisance. It would again be a private nuisance because again this is the question is on private nuisance. Also, it is a nuisance that the person was actually creating nuisance, and when again and again asked with the person, "Okay, okay, this should not be done," he still did it, right? The suit filed by A against decided in his favor, the action of B constitute a nuisance. The B is, A is the correct answer. Here you can see an act done under the authority of statute is a complete defense in an action for nuisance. So when you see here, it is complete defense with respect to the nuisance. So here we are talking about nuisance as such as a whole. The government of India ने पास किया था एक privatization railways act 2015, right? Under the act, the private companies were invited to participate in a tender to build and operate a railway line from Delhi to Jaipur. As per the provisions of the Act, the successful companies was to secure all the necessary permissions and acquire land for building the railway line. The enterprise was to be a private one with the government having no say in the ownership and operations of the line. Reliant Bambani Private Limited was declared as a successful bidder. So there is a bidder who got the successful rights. The company acquired land to build the line and project was completed in 2 years. After the commencement of operations, a real estate company, Gold Dust Realtors, filed a suit against Reliant Bambani Private Limited for nuisance on the ground that the constant noise and vibrations by running has depreciated the value of their high-rise apartment project adjoining to the line. Now you have to decide. So here we have to know whether the person has committed nuisance, whether what was the actions done. When you see all the options, the plaintiff, even though the actions of defendant constitute nuisance because the act is authorized by the statute. The suit will decide against the plaintiff because again here the statutory authority defense will come into picture, right? So answer is gonna be A again. So here there are two principles again. One is injury to the reputation, and then they are defining the slander part. So we can skip that part. We already know what is defamation. अगर defamation की spelling definition essentials की मैं बात करूँ, तो injury to the reputation of a person होता है in eyes of the others is referred to as defamation, right? Public होना चाहिए एक statement. It should be conveyed to the third party as well. So these are few of the essentials that you should know about defamation. Slander is basically the transit form और libel जो होता है वो defamatory statement होता है majorly, right? So when you talk about the facts here, there were two people, बोलू सिंह और रोलू सिंह. दोनों ने फाइल किया था नॉमिनेशन फॉर द लोकसभा इलेक्शंस, राइट? ड्यूरिंग द इलेक्शन कैंपेन, बोलो सिंह वाज सपोज्ड टू एड्रेस एन इलेक्शन रैली एट एलियनपुर. बोलो सिंह wrote a speech for the rally. तो बोलू सिंह ने proper speech भी लिखी थी for the rally. While addressing the rally, he read out his speech and made sketching remarks. He said that candidate contesting against me is thief and person of low moral character. Do you want such a person to represent you in the Lok Sabha? Rolu Singh filed a suit against the defamation against Bolu Singh. Whether it would be a defamation or not, Bolu Singh ने defamation किया या नहीं किया? Tell me the answer. Okay, so the answer is gonna be here. Yes, the statement that was said by Rolu Singh was directly harming the reputation. Sorry, Bolu Singh was directly harming the reputation of Rolu Singh. So it would amount to defamation for sure. The next is are the same facts and same similar principles. When you see the candidate contesting against, the what he said was the candidate contesting against me is thief and a person of low moral character. Do you want such a person to represent you in the Lok Sabha? So Bolu Singh would be liable or not? The answer is going to be A. He will be pronounced liable for slander as a statement was spoken to the general public by him, thus in transit, right? Coming to the principle of again the defamation. libel and slander, libel being publication, writing, printing, जो भी आपका written में हो जाता है. Slander again they are saying that कि it is oral, something एक statement बोल दी जानी, similar to what you might have seen in the social media platform these days, right? So X made a recording on an audio cassette in which he alleged that Y, the topper of UPSC exam, had cheated in the exams and also bribed the officials to tamper with the results. He also went on to record that the success of X can also be attributed to the fact that his father, Z, is a highly ranking minister in this government. X and Z decided to file a suit for defamation against Y. Suppose you are an advocate, X and Z approach you for legal counsel, you would. So what would you do? Advise them to file a suit for libel, as even though the audio cassettes contain spoken words, but since they are recorded, it is in the permanent form. The answer is gonna be B here. It is about malicious prosecution when somebody is held liable with respect to ones, and the proceedings that were done against someone were false. They can file the malicious prosecution against the other person later, right? This is basic. So there should be first any kind of you know proceedings to be there before. Okay, so A filed a suit for execution against B in Delhi High Court on its original side. B did not appear before the court, and the suit for execution was decreed in favor of A. The court ordered B to pay this decretal sum to A. B, however, refused to comply with the orders of the court. A filed contempt petition against B for willfully disobeying the orders of the court. During the contempt petition, A appeared as a witness before the court. The court ordered B to civil imprisonment. B challenged the order in the Supreme Court, and the order was reversed by the Supreme Court. B filed a suit for malicious prosecution. Decide. So here. Here the person will not be held liable for the, because first when he was there he was not guilty at all. So here he would not be liable. A will not be held liable as he is not guilty of malicious prosecution. While you see here A and B were business rivals who were dealing in men's garment. They both owned stores adjacent to each other in the market. B recently outbid A and secured a large order. The failure to win the bid did not go well with A. One day, a theft was reported in the store of A. A, while watching the CCTV footage of the store, noticed that a person resembling B had entered the store. The B had entered the store the previous night, but he was not sure it was B. A saw the incident as way to get even with the B and filed a complaint of theft before the police. The police arrested B and charged him with theft. Police investigated the case and caught the real culprit. B was released from lockup and filed a suit for malicious prosecution against A. Decide. So when you see, the answer is there are four options given. So A should be guilty of malicious prosecution, A is guilty, and A is not guilty, and A is not guilty. So here the answer is A is not going to be guilty, but which option, third or fourth? When we see that, then we'll realize that yes, the answer should be B here, because there is only one where A is not guilty. I did not prosecute B. He merely informed the police, right? Here again, we're talking about malicious prosecution. Let us see the facts. A was prosecuted by B on charge of theft of crops belonging to B. So there were certain crops that were, taken away, right? B also presented himself as witness before the court in order to prove the guilt of A. The court, in its wisdom, decided to discontinue the proceedings by applying Section 95 of the IPC. As in the opinion of the court, the matter was too trivial. A was released from jail and he brought a suit for malicious prosecution against B. Decide. Here, when you see, the suit will terminate in the favor of A, because as the proceeding in the criminal case terminated in his favor. So once the termination is already done, you cannot go ahead and say, okay, there was a malicious prosecution, right? You cannot say that. If he would have found guilty, then we could have said, okay, there was a malicious prosecution being there. In order to succeed in the case of malicious prosecution, reasonable probable cause must be shown. So here we need to note that there should be certain kind of reasonable and probable cause that should be done, right? If there is no reasonable probable cause, then we would not be able to identify it. A recovered a large sum by way of compensation from a registered railway company for personal injuries in the railway collision. Subsequently, the railway company got information that the injuries of A were not due to collision but were artificially created by Dr. S. The director of the company made inquiries and sought legal counsel, which suggested that Dr. S should be prosecuted for conspiring with A to defraud the railway company. A complaint was filed against Dr. S, but he was acquitted. He brought an action for malicious prosecution against the company, and now we need to decide. When we see all the options here, right, uh, the company cannot be held liable for malicious prosecution as they had reasonable and probable cause against Dr. S. Proper reasonable cause against S. The answer is gonna be B. Um, okay. So here it is about the medical negligence and the negligence of hospital authority, right? So there was this hospital and had a huge staff. It is one of the best cancer hospitals that we know can say of. There was one Mrs. Kapoor. She went to the hospital, had her tumor in her left breast. Since it was complicated case, there was a visiting doctor, a Dr. Memon, was called for the operation. The operation ended and was reported to be successful. On inspection, Mrs. Kapoor discovered the operation was done on the right breast against the tumor was in the left one. She sues the hospital authorities for the negligence of Dr. Memon decide. So here, if there is visiting doctor is not included in the list, and however he is independently liable for the negligent act. So you need to decide the liability of the person with respect to what principle is given. So here only Dr. Memon is going to be liable with respect to whole of the hospital, because here when we see there is another principle that states such. So then we can see about here the reasonable foreseeability. What is a reasonable foreseeability? When a person is to be held liable for a tort and consequent damage resulting, the original act must be reasonably foreseeable. We need to see whether the first act was certainly reasonably foreseeable. Can I foresee that act? Then and only then I'll be liable for tort. A owned a grand ship named Titanic after his wife. While on sail, a large quantity of oil gets leaked in the water because of the negligence of employees. Due to strong water current, it is drifted 1,000 kilometers east, where another ship named Rose was stationed. Right, Rose was an oil exploration vessel, and sparks on it were regular phenomena. One such spark spilled oil, and Titanic and Rose and engulfed in fire. The owner of Rose, Jack, brings a case of negligence against A decide. Here, A is not going to be liable because he could not have foreseen such thing, right? It was something which, even if you could have taken all the reasonable, what do you say, reasonable amount of steps, still he could not have been foresee that there would be fire that could have happened. Then there is a passage that is talking about majorly the wrongful act, the legal damage, legal remedy, injuria sine damnum, damnum sine injuria, right? These are the few things that we have already studied. But again, going for the passage here, just note down the basics here, right? When you see a passage, just skim read it. What is actually given? You already know what injuria sine damnum is, damnum sine injuria is, and you already know wrongful act, legal damage, legal remedy. You might have already studied that all in the class, right? So then go for the first question. Question, what is actually the question asking from us? It was election day and dude was very happy that he would get to vote for the first time. He had turned 18 finally. However, when he was in the way to the polling booth, Officer Badis stopped him from voting. Dude was an idle devotee and wanted the GJP party member, Dogface, to win. He wanted to vote for him but couldn't because Officer Badass stopped him. However, Dogface won, decided liability of the officer. Here, when you see his legal right was, cut down, right? His legal right was actually violated. When you see here, it would be injuria sine damnum or damnum sine injury. What would it be? It would be a legal remedy. The lawful act must be a nature, so he has to give legal remedy in form of actions of damage, right? So when you see this, you will decide that okay, whether the officer going to be liable. Yes, the officer is going to be liable because what it was a legal injury. The legal right of him has been violated. So sometimes you just have to use our common sense with respect to a number of questions, right? It would be just maybe the question and the answer would be without the passage as such. So you just go to questions first, then go for the passage. Siddhartha opened a school called Weisskal School to offer education to children of a particular locality. His enemy Janardhana opened another school, the East School, right next to it. The business of Weisskal School Siddhartha uh, Janardhana decide. The answer here would be Jan Dhanna is not going to be liable because there is no legal injury to Siddhartha as such. It is just competition. He could have also have done, certainly other things to maintain her school status. The mere fact that the man is injured by another's act gives in itself no cause of action, even if it results in loss to the other party, so long as other party is exercising a legal right. Sujit lives in a remote colony of Delhi. He has been running a cyber cafe there, offering internet services for more than 5 years. Being the only shop of its kind in the area, he has been making good profit. Verghese opened a coffee shop in the neighborhood and also provided internet access to his customers free of cost. As a result, internet business of Sujit is affected and he starts suffering losses. After some time, Sujit had to close his business. Sujit wants to bring a suit against Verghese, right? So Sujit has no cause of action against Verghese. He could have updated himself. He could have gone ahead and done something. So this, even if this question is coming under torts for you, then you have to accordingly think about the torts. If this question is coming under with respect to competitions law, then you have to think about that, right? X had been teaching at St. Xavier's College since many years. His relation with the school management became strained due to his meager salary, so he started his own school just opposite to the college, owing to which the number of students taking admission in St. Xavier's reduced and they suffered huge financial loss. Can management authorities of St. Xavier's College sue X for compensation? The answer is yes, the management authority cannot sue X for there is no legal injury that has been harmed here. An actual damage to a person or his property without legal injury does not give rise to cause of action under law of torts. A bike racing competition on a national level was organized in Dehradun, which was attended by a large number of people. Many races from across the country participated in it while the race was going on. A few over-enthusiastic people from the audience jumped over the fence and started cheering. They failed to take note of the fact that the bikers were moving at a high speed on the race track. At that very moment, a bike hit them and a man named Mr. Fan died on the spot. The racer was saved because of the proactive gear he was wearing. Decide. The answer is going to be D. There is no legal cause of the action in this question. There was no legal injury, no legal action as such, right? Going forward, a legal injury without actual damage is a cause action under law of torts. Joseph invited his friends Stalin, Lenin, and Sophia for a dinner party at his house. Okay. So he kept a condition that he would attend the party only if Sophia refused to come. Joseph tried to placate Stalin, but not to avail. So he assured Stalin that Sophia will not be invited, but everyone, included Sophia, was present at the dinner party. Joseph later on revealed that he could not disinvite Sophia. Stalin is now demanding that Joseph should use Sophia for trespass. Decide. So this is not a trespass at all, right? This is not at all a trespass. So the answer is going to be only Joseph cannot file a case for the trespass. Injurious in damnum means injury without damage. Injury means violation of legal right, which tenders the action in law of torts. X who was a returning officer at the polling booth in Faridabad, wrongly refused to register a duly tendered vote of Y in the assembly election, even though Y was an eligible voter. The candidate in whose favor Y wanted to vote was declared elected. Give the most appropriate answer for the options given below. The appropriate answer can be Y can sue X on the ground that he was denied the right to cast a vote, which is a legal right. A violation of legal right without an actual damage gives rise to torts. Ram and Ghanshyam were two contenders among the candidates who were supposed to receive ticket from the political party GHI for the election of House of People while they were not gathering support for themselves. Enmity developed between them and each one took steps to ensure that the other one does not receive tickets from the party. Ram, to get rid of Ghansham, planted a bomb in his garage, hoping that the bomb would explode while Ghansham is in garage. However, the bomb did not explode at the right time and Ghansham escaped. Can he sue Ram under torts? The answer is gonna be A. No, he did not receive any. Sorry, the answer is gonna be B. Yes, he can sue Ram as he violated his legal rights. The answer is gonna be B here. The following is on the voluntary non-fit injuria. Something if you're voluntary consented at certain place, and then you cannot ask for the damage. Okay, any repercussion that are going to be there, then you are going to be liable, right? Not the other person. A and B planned to go to shopping. Each suggested that instead of taking separate vehicle, we could come along with him in A's car. B agreed on the way. B noticed that the brake of the car were not functioning properly. Few minutes on the road, the car met with an accident with A, B, and sustaining injuries. B filed a suit for damages against A. Decide the suit. The answer here is that B should be awarded the damages because he was not aware of the failed brakes. Right? A and B planned to go to shopping. A suggested that instead of taking separate vehicles, B could come along with him in A's car. B knew that the brakes of A's car is not working properly. However, since the market was not very far, therefore any mishap is not likely. B agreed. Few minutes on the road, the car met with an accident with both A and B sustaining injuries. B filed a suit for damages against A. Decide the suit. The answer is going to be B should not be awarded the damages because he knew the brakes of the car were not working. Moving on. Okay. T had taken a huge sum of money from J to invest in the share market. T hoped that he would repay the sum of with interest after earning huge profit in the share trade. However, after the elections results, the share market crashed and T suffered heavy loss. It was impossible for him to repay the amount, hence he offered his service to J, who employed him in one of his mines. One day while working on the mine, a huge slab of stone fell on T's foot and he had to undergo operations and quit working for a few months. T filed a case against J for negligence at his mines. However, J argued that since T accepted the offer to work is a risky environment. Therefore, he does not have any right to claim compensations. Decide the fate of the case filed. Here, when you see the answer is going to be C, that T should get damages because he did not willingly accept the risk of employment. Which of the following is essential of voluntary non-fit injuria? The plaintiff has knowledge about the risk, but strongly assumes that he would not operate. The plaintiff has no knowledge about the risk. The plaintiff has knowledge about the risk but could not anticipate the gravity of the consequential harm. The plaintiff has knowledge about the risk and willingly suffers it. So answer is going to be 4 here. The D is the answer. G and H were opponents in a boxing match during one of the rounds. G landed a very hard punch on H's face after all the rounds G won. While going back to the green area, H hit G on the face and saying, "You reap what you sow." D filed a case against H in the court. H argued that since G voluntarily participated in the boxing match, he willingly undertook all the risk and comes with it, one of the which being hidden by the opponent. Decide the validity of H's argument. The answer is going to be A. H argument is invalid because G has consented for the risk, right? So voluntary non-fit injuria's basic concept lies here that yes, A's argument is going to be invalid. We walked through a railway tunnel to fetch fresh water from the river that was situated beyond the railway tunnel. It was long and narrow tunnel. On the way in the tunnel, P saw a train coming from the other side. However, there was no whistle or warning as he has been given earlier. P could not run to the other side of the tunnel and subsequently met with an accident. His family filed complaint against the railway company for not issuing any warning. Moreover, the train driver did not whistle, neither slowed the train. Even after spotting B on the road, decided the validity of the suit filed by the P's family. The answer is going to be A. P's family shouldn't get the compensation because the railway company was negligent. Gent, right? Last question of the day. R worked in the farm that housed several untamed bulls. Though the danger of handling the bulls was high, but they were kept inside a locked cabin, and R's duty usually ranged to preparing hay for the food and cleaning the area. Thus, he never came in contact with the bulls. One day, while R was busy preparing hay and straw for bulls' food, the guard forgot to lock up Bull's cabin. The bull saw the food and rushed to get it, and meanwhile, R was heavily injured. H filed a case against the farm owner to decide the validity of the case. The guard was negligent in locking the cabin, thus the owners must compensate R. So here it was, something which was negligent on their part only. That is all. We discussed negligence, we discussed malicious prosecution, we discussed nuisance, we discussed reasonable forcibility, we discussed voluntary non-fit injuria, we discussed injuria sign damnum, we discussed damnum sign injuria, we discussed what is legal remedy, we discussed when the right is being infringed as a legal remedy, what is a remedy, sorry, damage that, what is the remedy that is available for you. So all these things we already discussed today. If you have any doubt, just put it down in the comment box and we'll discuss later. Bye bye. Take care, students.